case. It's not that this is a state that has charged him with, for instance, assault or battery, but rather racketeering. How does that help, or does it, the state's case?
It does help the state's case because you have prosecutors in the Eastern District of New York there in Brooklyn that are using these racketeering statutes, just like they did in the NXIVM case, to prosecute these types of sexual predators. And you can get underlying state offenses, for instance, the assault with the respect to the herpes. So it does allow the prosecution to really broaden the net, bring in a lot more relevant information into the fold, and they have still charged the substantive Mann Act offenses. That's the sex trafficking across state lines. So this allows the state to get a lot more evidence in, and you really have two different ways to secure a conviction against R. Kelly, whether it's the RICO, the racketeering statutes, or the Mann Act.
Does it matter if there is any perceived bias by the media against or for R. Kelly at the end of the day when a jury has to make that decision?
I don't think it matters that much with respect to what the media thinks, but let's be honest, jurors love celebrities, and there's a reason R. Kelly was acquitted in 2008. And generally, celebrities can afford high profile, extensive defense team. R. Kelly isn't being represented by a public defender there in the Eastern District. So, these are all things that tend to favor the defense when you do have a celebrity defendant. And oftentimes, the victims in these cases, they can be beat up a little bit on cross-examination or even during opening, like we saw the defense. They're labeling them groupies. Some of them have entered into civil settlements with R. Kelly and his team. So it can be challenging if you're the prosecution, especially in a case like this where there's not a lot of independent evidence that we like. We like video as prosecutors. We like audio. You're really relying on the testimony of these victims who, by the way, I think have been outstanding so far, both Geronda Pace and Jane Doe 5. But again, it's more difficult than your typical case where you have this independent evidence that can't really be subject to cross-examination like these victims can.
Into deciding which of the defense team counsel are going to question these female victims, because we just note that Julia said, oh, it was a male who questioned Jane Doe number 5. Is that strategic in your opinion?
Absolutely. There are certain attorneys that are better at cross-examination. We see in the Durst trial that we're covering right now that Dick DeGuerin, who's one of the best, he's cross-examining many of the witnesses. There's others who may be better in law and emotion, or maybe better in direct or closing arguments or summation. So, as attorneys, we all have our strengths and our weaknesses, even though we don't like to admit it. And particularly when you're dealing with a female victim of alleged sexual abuse, you have to be very careful. You don't want to be overbearing, but you want to get in and score those points, because ultimately, it's going to come down to their credibility. Ms. Pace, Jane Doe 5, if R. Kelly is convicted, it will be solely because of the testimony of these victims. So you have to go after them aggressively in cross-examination, but not so much so where you turn off these jurors.
That's right. You never want to alienate the jury.
Actually, a lot of information came out in the preliminary hearing. When Barry was originally arrested, the prosecutor in Colorado, she was very confident, but she didn't really provide a lot of information or evidence that would implicate him. And now we've seen it. Obviously we have the motive. Ironically, Suzanne was concerned about Barry having an affair, but she was having an affair. And, the cell site evidence where he's traveling outside chasing after her, and those tranquilizer darts, and ultimately when he's arrested, he has no explanation for these trash runs. He doesn't say or even know or remember as to why he made multiple stops to dispose of items when the trash comes to his house every day or every week, just like the rest of us. And he doesn't know what, if anything, he threw in there. So I think that's the type of evidence that a jury will hang on to, because it really doesn't make sense, and he doesn't have an explanation as to why he has these tranquilizers, why he's disposing of all these items, and really what he told law enforcement doesn't make a whole lot of sense, that he was outside shooting chipmunks. Very compelling, Ashley, and this is why. The cadaver note is the key piece of direct evidence in this case. Really, the only direct evidence in this very circumstantial case. And not only is it direct evidence, it actually prompted the admission during the Jinx when Durst was confronted with the cadaver note. That's when he went to the bathroom and we had the famous hot mic incident. And not only that, this is the easiest provable lie that Lewin has been able to show this jury, because for years, both to him, both to the producers of the Jinx, to everyone, Durst said that he didn't write this note, and only when he was forced to, because Judge Wyndham ordered a handwriting analysis, did the defense sort of shift their strategy back in 2019 and finally admit that Durst wrote this. So this is critical evidence, and I understand why Lewin keeps pounding it for this jury. He's going to let this go for days. I mean, we've obviously seen parts of the Jinx, all good things. We've seen movies in a courtroom. This is Hollywood. But I really like what Lewin is doing here because he's boxing Durst into a corner. And I know Chanley likes to do her own investigation, and I encourage her to do so because Bob Durst's story doesn't make sense. He finds his best friend murdered. He tries to call the police from her house. He says the line's disconnected. And then what does he do? He drives 2 miles away from Benedict Canyon to Sunset Boulevard, picks up a payphone, calls 911, and when the operator picks up a female, he hangs up. But then what does he do? He's visiting from out of town. Somehow he goes and buys a letter, an envelope, some stamps to mail this letter to the Beverly Hills Police Department. Again, story doesn't make sense. I know the defense is going to pound reasonable doubt during their closing argument, but Lewin's going to say, is this story reasonable? And by locking in Durst to this unreasonable story, it may be the best chance for him to get a conviction here.
And the technicality cited is a failure to turn over financial evidence by the prosecution. That's a problem. I mean, these are the things that happen that cause cases to get thrown out on technical reasons. What are your thoughts?
Ashley, it's a technicality, but a big technicality. A lot of action here in Southern California today. I can pretty much see Chanley from my office. And this is also here in the Central District of California in Orange County, where Judge Selma essentially said that the U.S. Attorney's Office violated Brady, which is a Supreme Court case that says you need to turn over exculpatory evidence. So the U.S. Attorney's Office and the federal prosecutors in this case failed to comply with their discovery obligations, at least according to Judge Selma. So this is a big setback for the prosecution, a black eye for the whole office, and now they have to retry this case and start all over. I think ultimately the result will be the same. There's plenty of evidence, and Avenatti will be convicted, but this is not how you want to start your case if you're prosecuting someone who's also an attorney.
Right.